New York has said that two people of the same sex can get married. 30-some states will not recognize same-sex marriages from other jurisdictions, and a smaller number of them will not recognize civil unions or domestic partnerships. When a couple that's validly married in a state moves to another state, in general, that other state will recognize that marriage. Some states, however, have state laws that are sort of like the Defense of Marriage Act. Sometimes they're called state or mini-DOMAs. If you were married in Massachusetts and wanted to drive across the state for vacation to California, your relationship status changes when you cross state lines. If you drive to Virginia, you are no longer married in the eyes of that state. Same-sex marriages are, simply put, void. It's as if they never happened. But then by the time you get to Iowa, Iowa will view you as married. In New Jersey will treat you as in a civil union and will give you the same benefits you would get as married. Other states won't. Iowa, which recognizes same-sex marriages, will not recognize a civil union for anything. The Defense of Marriage Act defines marriage for purposes of federal law as a relationship between one man and one woman. Married same-sex couple, viewed as married by their state, will not be treated as married for purposes of federal law. So they can't file joint federal income tax together. They can't use their relationship as a way of qualifying for immigration or naturalization. They can't get veterans benefits or Social Security benefits in virtue of their relationship. The Obama administration has taken the view that the Defense of Marriage Act is unconstitutional. Laws that make use of sexual orientation categories get heightened scrutiny, which is a hard standard to satisfy, and they acknowledge that the government can't successfully defend a law that makes use of sexual orientation classifications. Congress, however, has decided that it's willing to defend the Defense of Marriage Act, so there's not going to be a default judgment. We have different states doing different things. In this case, we have different parts of the federal government saying different things. You have the legislative branch saying, we passed this law, and at least some of them saying, and we think it's constitutional. This is the law of the land, and we're going to defend it. The executive branch saying, we think this law is unconstitutional. If the Supreme Court says it doesn't violate the U.S. Constitution, it probably would hurt future arguments in other states. Some state Supreme Courts have, interpreting their own state constitutions, have found that it's unconstitutional under their state constitutions to prohibit same-sex couples from marrying. That's what happened in Massachusetts, that's what happened in Iowa, that's what happened in Connecticut. And state constitutions can say different things. They could be more rights protective than the U.S. Constitution, but they are in some way influenced by the highest court in the land.